welcome to everybody to this session by the Mint House. My name is Myra Blythe. I'm a trustee at the Mint House and also research in restorative justice here in Oxford. It's superb to see such a huge selection of people from different continents. We have people from Asia, from North America, and from all over Europe, as well as a good number here from locally in Oxford. So you are all very welcome, and it's my very special pleasure to welcome our two specialists to introduce this important subject of the intersection between restorative justice and environmental justice. Excited to welcome Professor Ivo Aertsen, Professor Emeritus at Leuven University in Belgium. Welcome, Ivo. And also to welcome Lawrence Kershen, Mediation and Restorative Justice Specialist and former London-based lawyer. Welcome, Kershen. So Ivo will introduce the topic of environmental restorative justice to us and will include how restorative justice can be adapted in cases of environmental harm and some of the needs and the challenges involved in making this intersection happen. He will speak for about 15 minutes, and then Lawrence will pick up the microphone, as it were, to share from very practical experience as a facilitator, reflecting on how environmental restorative justice happens in cases. He will focus on one case in particular, and he will also speak for 15 minutes. That will leave us, theoretically, 25 minutes for open questions and discussion when your particular interest can be highlighted. So I hope that you will feel able to register your desire to speak either by placing a question in the chat box or just raising your hand so that I can see on the screen that you would like to speak. So welcome everybody, and I take no more time but turn immediately to Ivo for your introduction to environmental restorative justice. Thank you, Ivo.
Thank you, Myra and Joy, and thank you for inviting us here for this challenging topic that we will discuss today. And a challenge will it also be to do that in 50 minutes for me, but I will do my best to restrict it to this time. So let me first say what our background is and where we get our sources, our information from. Both Lawrence and I myself are member of an European Forum for Restorative Justice working group on environmental restorative justice, where we also working on a forthcoming practice guide and where we have studied some cases and where we have also done some European policy-oriented work. Furthermore, we get information from recent publications as the Palgrave Handbook and a special issue of the International Journal of Restorative Justice from some 2 or 3 years ago. Now, what are we talking about? We are talking about environmental crime and environmental harm, I would say. Environmental crime is something we might be familiar with. It refers to many of us to several types of unlawful acts, such as pollution offenses and transportation of banned substances and so on. Environmental harm is a much broader notion, of course. Environmental harm refers to behaviors, human behaviors or omissions or negligence, criminalized or not criminalized. And they refer to a complex, it's a complex and multi-layered phenomenon, so to say, because when we talk about environmental harm, you can immediately imagine that we are talking about many different things, many diffuse things maybe as well. We are talking about natural resources that might be harmed, but we are also talking about public infrastructure, heritage, meaning that people give to the environment, and also not to forget the impact of environmental harm on future generations. Environmental harm does not appear in a vacuum, I would like to stress from the very beginning. Environmental harm has very often deeper roots, must be understood in its historical, social, economic, cultural, political context very often. And finally, it goes back to our relationships with nature in general. Now, there are a number of characteristics that contribute to the complexity of the phenomenon, the complexity of environmental harm. It is often, there's often a high degree of invisibility of the harm in terms of their effect over a longer period of time. Sometimes there's a long latency period before harm becomes visible. Harm might be often very diffuse at the individual level, but also at the collective and the community level. And important to say is, of course, that we are not talking about human beings, but also other than human beings to be involved in our restorative justice processes. There's often a lack of clarity as well about the causal relationships and whose responsibility, whose accountability is at stake. Those responsible are persons or entities are often not so easily to be personalized or identified. It can be persons, companies, public entities. And very often these environmental harm cases have a cross-border character as well. So that makes it all very complex and multi-layered indeed. But we have understood in the meantime that when we really would like to cope with these environmental harms, when we also want to include the other than human dimensions, the nature, the ecosystems, when we want to understand our relationship with nature, what might be the harm and how can it be restored, then we know in the meantime that we have to shift in our mindsets. And generally speaking, we call it a shift from an anthropocentric to an ecocentric approach. We should not look at the phenomenon, at environmental harm, just from our own human perspective, but we should approach nature with rights on its own. Now, can we apply something as environmental restorative justice? The central question might be whether, how, and to what extent can restorative justice offer a more inclusive, a relational, an encompassing, and effective approach to environmental crime, environmental harm, even ecocide, for example. My answer is yes, we can. But restorative justice, with its well-known values, principles, concepts, with its traditional focus on interpersonal, conventional types of crime, well, this idea of restorative justice will have to be rethought, will have to be reshaped, including our notions of crime and harm, but also we will have to rethink our understandings of concepts such as offenders and victims, the community, what about participation and so on. In short, we will have to develop and to conceive new models in practice in order to involve all the stakeholders, human and other than human stakeholders in practice. Now I would like to very quickly discuss 4 or 5 important levels of our dimensions that we have to take into account and that we have to adapt, I think, when we want to develop environmental restorative justice. First, I would like to say a few words about the victim dimension. And when we talk about corporate crime, corporate environmental crime, there are many levels of victims and victimization. Victims can appear internally to a company, employees, shareholders, but we usually identify ourselves very much with external victims, citizens, the local community, harmed people with no relationship or not direct relationship to the company. These are all human victims and their environments, but also know how to involve these other than human beings, other than human victims, how to give them a voice in the process. And we know that a special attitude, special skills will be needed to do that, to adopt the skills and the attitude to listen to the voice of the nature and to include this voice in our restorative justice processes. talking about the victims, a principle could be that we agree that all categories of victims should be able to receive recognition from the harmer for the harm suffered, should be able to receive information on what happened, on the causes, the circumstances, and the responsibilities around harmful events, should be able to receive financial compensation or restitution in natura for their material and non-material harm. What we also know from research and practice is that a central need for victims, also in these cases of environmental harm, that a central need for victims is to be heard personally and to be able to tell their story. Sometimes a personal individual approach will be needed, sometimes a group approach. Moving to the side of the perpetrator or the offender, we understand that the big challenge is how to create a space for open, non-defensive communication so that the disconnection between the harmer and the harmed can be lifted in order to make it possible that corporations' representatives can begin considering their responsibilities as a corporation. Now, immediately we ask ourselves the question, why a company would participate in a restorative justice process? What might be their motivation? Often, social, political, judicial pressure will be needed to motivate a corporation, of course. And of course, there's also a good degree of self-interest. To make financial deals with the victims might be much more easy and simple and cheap than go through a judicial process. But most of all, for many corporations, it is a matter of reputation and public image. And that might be their main motivation to engage themselves in the restorative justice process. Here it would be interesting, but we don't have the time, to think about evolving ideas about corporate social responsibility. It is also important to think about notions of business ethics, I think, and how this business ethics understandings and the literature on this is constantly evolving as well. How more and more there's an awareness that benefit-making companies, should not only have the duty to make benefits, but also should have the duty to function, to do something to society. From the offender perspective, I would like to move to the community dimension. The community, in cases of environmental restorative justice, is often embodied by representatives of the community, of course, or the representatives of interest groups, or in other cases by surrogate victims or governmental representatives. We can learn a lot from variations on restorative justice models and processes, I think, in order to be able to involve the community or various levels of the community. We can learn a lot from sentencing circles, for example, or community impact panels as potential practical tools for active community participation. Although there might be some risks there as well, when we start involving the informal, the wider community. There might be a risk, for example, of power imbalances in the group and so on. But all by all, involving the community or the broader community might have important benefits for society on itself. It is a way for a community to develop its social capital, its social networks, and its interconnectedness, I would say. Then I would like to move to the notion of participation.
And let's give you the last 2 minutes, please, Ivo.
What is participation in this case? We have a plurality of stakeholders here, a very diverse nature. And who to involve the stakeholders? Well, that's a big challenge. We have also seen that in our working group of the European Forum, when we were discussing cases, it is a challenge. It's an important first step to identify the stakeholders and to get them on board, to bring them to the table. Yeah. So always a case-by-case approach will be needed. But again, conceiving modes of participation, other models related to restorative justice or transitional justice might help us a lot to conceive participation and how these all people and groups can participate. And I think we can learn, for example, a lot from Truth and Reconciliation Commissions, because there it has been possible to involve larger groups and to exercise public censure and so on. So these models might be interesting for us, I think. Usually, talking about participation, we know that storytelling, truth telling is important, but also truth in its narrative meaning, in its relational and dialogical meaning. We are, of course, not just talking about truth in its factual or legal meaning. Restoration is a complex dimension as well. Victims, generally speaking, prefer reparation directly by the victim. Models of reparative justice have been developed, for example, in Australia, where restorative sanctions are being imposed by the court. It's a mixture of punitive and restorative sanctions, I would say. Interesting are the experiences from New Zealand, where according to the law, community conferences can be applied for environmental harm. I come to a conclusion. I think restorative justice theory and principles offer good arguments, I think, to bring ideas into practice in complex contexts of environmental harm. There are promising creative practices already, but what is needed is much more advanced test cases. I think we need much more experience, much more cases where we can learn from. And that's, I think, a good moment to now refer to Lawrence and to listen to him. Thank you.
Thank you, Ivo. We turn immediately to Lawrence to pick up from that very helpful presentation of Ivo.
Thank you, Mara. Thank you, Joy, for allowing me to be part of this, and thank you, Ivo. It's a pleasure to hear your overview, your big picture. I'm afraid I'm going to come down to a rather smaller picture, which is some of the practical experience that I've had in this field. And it needs to be said that it is at its early stages in many ways. We're a growing experience of environmental restorative justice. My motivation, it may be worth saying, is that I believe that we, all of us, are in a kind of conflict of needs. We both want and need a healthy and sustainable planet. In fact, we all have, we are part of an ecosystem, and it's foolish, I think, to try to divorce ourselves from the fact that we are part of this natural world. At the same time, we have a continuous and ever-increasing need for energy. And indeed, we wouldn't be having this meeting now were it not for the fact that we have a reliable and continuing source of energy. So we're both the victims and the beneficiaries of this climate, environmental and biodiversity crisis. And the question for me is, how do you resolve that split? And of course, you might expect, having been a mediator for 30 years now, I think that dialogue is an answer. I don't say it's a universal panacea, but it is an essential tool to move through this crisis. So let me turn immediately to the forms of dialogue that I believe work in environmental issues. One is, of course, mediation, and that is my background in the commercial world. And I've done some mediations, facilitated some mediations where environmental issues were a part of it. And it is a way in which to resolve an environmental conflict. For example, the purchases of land, which turned out to be contaminated with hydrocarbons, the settlement, the agreed upon outcome, was a resolution by way of payment of money, but also remediation of the land. And that, I think, is a form of environmental mediation, restorative action. There's also stakeholder dialogue, and Ivo mentioned the idea of stakeholders coming together. One facilitation that I was part of was for the decommissioning of a nuclear power station. And the question for the Nuclear Energy Authority was, how can this be done in a way consistent with the needs of the community and, interestingly, the needs of future generations? And it is quite heartening to know that that is part of the Nuclear Energy Authority's remit, to consider the impact on future generations. But specifically, I want to turn to restorative justice. All of these forms, of course, have common features, and the central features that I would highlight are that it is a safe space that the facilitator creates, and Ivo referred to the idea of removing some of the adversarial nature that certainly I used to see in the courts. There is a neutral facilitator. It is a voluntary process. It is confidential, mostly. It may not be, but that's part of the ground rules that have to be agreed ahead of time. And the outcomes, or the resolution, is one that is agreed upon by the parties rather than imposed by the facilitator, as you will, I'm sure, be familiar with. So the one example that I thought we might usefully focus on is one that I completed recently involving the Niger Delta. And it wasn't typical in the sense that it was all conducted online. I didn't physically meet the participants. I did eventually, but not in the course of the process. It started in February 2021, and the issues were these. As you may know, oil extraction has been going on in the Niger Delta for the last 50 years, and there have been some benefits to the local community. There have also been really awful environmental consequences of that oil exploration. And the approach was made to me by an activist representing, he said, a number of communities in the Niger Delta to seek some sort of restoration from a particular oil company, which I'll call Oilco for these purposes, for some of the environmental harm that had been caused. And the process, as I say, started in February 21. It finished in October 2022. That's the process itself. And the outcome, or the action that was agreed upon in the process, just finished in August of this year with the first commissioning of sustainable power grids set up in some communities, or a particular community in the Niger Delta. The process was preceded by a series, or started with a series of private meetings, and anyone who's familiar with either mediation or restorative justice will know that those private meetings are an absolute necessity in order to build the sense of safety that I think the facilitator is seeking and the parties need. Then we had a series of meetings. There were probably 6 or 8 online meetings with Oilco and the activist and others whom the activist was allied with. And at the end of that process, there were multiple possibilities and options that arose in the first place, but it focused in, as the discussion continued, on this situation, that those communities in hard-to-reach parts of the Niger Delta were relying for their energy on illegal extracted oil, which was mostly done by organized gangs. And the result was that the communities had energy, which was basically stolen from and sold to them, stolen from Oilco. and it was causing massive pollution, just that aspect of the oil extraction industry. And what emerged was the possibility that Oilco could facilitate the installation and maintenance of solar mini-grids, meaning low-cost energy from sustainable, clean sources. And the benefit of that was that the communities would no longer be dependent on this polluting and illegal oil kerosene, actually. So the process started, the discussions continued, but it threw up 4 or 5 specific issues, a couple of which Ivo has already referred to, at different stages of the process. And I'm going to just highlight those, if I may, in the time that I have left, which is not a lot. The first was, why engage? Ivo's talked about it. What would make an oil company want to engage? Well, one reason is that in the background there had been litigation, both civil and criminal, which had brought the oil company to the table, and indeed, in some respects, they were themselves the victims, or they were the victims of the outcome of those litigation processes. So the possibility that they could stop further litigation was, I think, a factor in the background. But more than that, I had, in my role as facilitator, to outline to them some of the potential benefits, not just litigation, avoiding litigation, but what is the business case for a corporate to engage in an environmental restorative justice process. And working out what the business case was, which I hypothesized but talked through with them, included ROI, which I came to understand was return on investment. What if they invested time and money in this process, would they get out of it? Well, obviously they'd potentially save time, money, and stress later on. It would enhance, or could enhance, their reputation. So that's the second element. It would enhance their engagement with the community. And we talked about social capital, and I think that would be within the definition of social capital, that the antagonism the local community had towards the oil company would be reduced potentially if they could engage with them. And of course, on the wider scale, they could have a more effective process of oil extraction. Whether you think that's a good idea or not, it isn't quite the subject of this discussion for the moment. So you'll understand it wasn't a typical process, apart from the fact that one of the questions was, how far do we go? In other words, clarifying objectives, because the oil company said to me, look, if the point of this process is to stop us extracting oil in the Niger Delta, it ain't going to happen. And of course, in the longer term, one hopes from a human point of view that that might be the case. But for the specific process, it could not be. And that was a red line. So clarifying objectives became a second element. Confidentiality of the process, I've already referred to. The voluntariness needed to be emphasized, the fact that if they reached the point where they were not happy with the process, that they weren't happy with what was being demanded of them, then they were free to step out of it. So emphasizing voluntariness became a factor in creating the safe space. And then the last element that I referred to was the authority to negotiate. In other words, the activist who started the ball rolling said that he represented nearly 1 million people in the Niger Delta. And the oil companies said, well, how do we know? Who is this guy? He's come out of the blue. You, Mr. Facilitator, say that he's sincere, but how do we know? So we spent quite a lot of time exploring what authority he had for engaging in this process. And it was a legitimate question, and it was one that could be answered and was answered to the satisfaction of Oilco. as a result of which we went forward. So it raises the question, who are the parties? The bigger question is, who else should be involved? And as Ivo has says, there are the individuals, the communities, there are the businesses, there are also the regulators. And the missing link sometimes in this process that I think is crucial to achieve if we can, is engagement of public bodies such as the local authority and indeed the government authority that oversees these sorts of processes. So as well as the non-human or other than human parties that could be, should be a part of an environmental restorative process, there is also, of course, the governmental bodies who enable the process to take place in the first place. So those were questions that had to be answered and indeed were answered, not all of them in the specific way that I've referred to, but they had to be dealt with in the process. So it ended in October of 22, and what then happened was that the time between then and June of this year was spent in the actual physical building of and installation of the solar mini grids to which I've referred. And in June, they went live. In August, they were commissioned, so there was an official ceremony. And at this moment, I believe, several communities in the Niger Delta are benefiting in a very tangible way from sustainable, clean energy, which came out of an environmental restorative justice process. I'll add one other thing, which is that not just those communities for their heat and their light, if heat is an element in the Niger Delta, I'm not sure, but not just those communities, but productive use, which I came to understand is the ripple effect of the benefits of sustainable energy, meant that businesses could be set up, such as, for example, a chicken farm, which couldn't have survived and didn't survive previously because energy was so unreliable. Now a continuous and reliable supply of energy means that a business such as the freezer element of a chicken farm can be built successfully, and the wealth that is created from that business can then diffuse out into the surrounding community. So you can see that the ripple effect of using an environmental restorative process can benefit a much wider community than the ones who are actually participating in the process. So those are some thoughts. Myra, how am I doing on time?
That's fantastic, Lawrence. I think we've reached the stage with both of your presentations that we should open up the floor and invite comments as well as questions from our participants. So I am looking on the screen and I ask Joy to do the same, to look out for questions. I have one question here. You can either raise your hand or put it in the chat, but there's a question here from Olivia, which I think perhaps links to what you've just been talking about, Lawrence, in terms of, she says, in restorative processes, do you find that the language of reparation is resisted and companies prefer to talk rather about compensation or negotiating payments? I think that touches on your red lines. It's like they will talk in certain conditions, but it has a very strong limit. And then that raises the question for the local community and for activists as to when does the discussion lose its legitimacy? When can they raise the bigger stakes? I give you an example. Here in the UK, in Scotland, there's a case coming up very shortly in November at Rosebank about the Rosebank oil extraction. And the company Equinor, they are technologically capable of generating energy from renewable sources. So investing heavily in that is the bid of those that are demonstrating against the new licenses being given to that oil company by the government. So how do we kind of balance this, the local spin-offs that companies are willing to give as a kind of compensation, but the lack of dealing with the head-on question of oil extraction over against renewable energy investment. And that picks up your thing about where are companies ready to invest when it will not gain them the same profit?
Shall I, Ivo, shall I have a, a stab at answering that and then hand over to you? I'm not sure that the language of compensation and reparation is one that I would want to get too caught in setting up this process. As a lawyer, there would need to be a very clear claim and a very clear defense, and we would be talking about the specifics of what's on offer. As a facilitator, I would want to keep things much more fluid as we go into the process. And so if it comes to how restoration might take place, would it be compensation, reparation, or I think you used another word, Myra, I'd keep that very loose and not get caught in the language. Because for me, it's having parties there together, having them be able to talk to one another frankly and in a straightforward way, is what throws up the needs of each party. And however we label those needs, it may come down to the same thing in the end, and not to get caught in the language, I think, is important. But I think you're also asking another question, Myra, which is about there are underlying issues which you might say are more fundamental than the one presenting in the environmental conflict. And I have to say that on the one hand, we deal with specifics in a restorative process. I don't see, perhaps one could imagine a restorative process where you've got the oil industry on the one hand and the planet on the other, but that's a very big discussion to try to have. That's a very big issue to try to resolve. And I would want to kind of bring it down to specifics. The debate, of course, is vital, but I think that in a ERJ process, one needs to look at a specific harm and a specific response to that.
Okay, thank you. Let's pick up the question now from Raina Bergas.
Hi. My question was kind of about the case, and I'm just wondering how much communities get influenced by outside perception or outside factors and opinion during the mediation process. Like, for example, you mentioned that the communities were receiving their energy from illegally extracted oil from gangs.
Yeah.
But were the gangs at any point putting pressure where the communities might have felt that it would have been dangerous to accept some kind of thing that would mean that the gangs don't have a market to sell their oil anymore? But in a broader sense, I think sometimes there might be a process like this happening, and public perception might be like what you said, like oil should just not be extracted anymore, where that's just not a possibility. Like, do you think there's a recognition that the community's needs should come first?
Well, it's a good question, and I don't frankly know the answer to it, but I did think this, I did have the same question myself, which is to what extent are the gangs resistant to this process? I think it had moved beyond their control. I don't think that they were able to influence, for example, the activist who himself was a very courageous and altruistic individual. I don't believe he was in any way influenced by them. And I think it really, as long as he was speaking about the community's needs, it had bypassed the gangs. But it's a real question. I asked it of myself. It didn't seem to affect the process that we were.
Okay, thank you. Now, I want to take one of the questions from the chat box and refer this to you, Ivo, because it starts from the case study, but it's a broader question which you raised in your presentation, and that is the rights of nature, the rights of more than humans in this process. This is a very controversial area. Who can speak for nature? What light can you shed on any developments legally that give some sense of progress around this discussion about the environmental harm and the rights of nature for restoration?
Mm-hmm. Yes, a good question indeed. I would like to make the distinction between two elements. There are places where some elements of the nature are recognized legally, where a river has legal rights. And more countries have this, where a river has legal personality. Sorry. Mm-hmm. And that means that there are also procedures then to legal procedures to represent the river in this case. But I personally do not have that much experience with that. Easier is to talk about the second level. The second element is in very informal processes, restorative justice processes, how to include the nature, the other than human beings. Usually this is done by representation, by representatives of activists groups, for example, who are taking part in the restorative justice process and talking to the company, for example, and to the other stakeholders. Can be also experts, very often experts, people from researchers or policymakers, experts, governmental experts or scientific experts who can make clear in the process, in the process of the restorative justice, what the consequences for nature, for the ecosystem in the long run might be of this or this case. So, and then also, governmental representatives, as Laurens also mentioned, can play an important role there. Or representatives of regulatory bodies, public bodies, regulatory bodies, who know very well what the consequences for nature are. So that is a way how I think we can represent the nature or the other than human beings. And of course, you have to be very creative. And I have seen also cases in France, for example, where nature was represented in a creative way by pieces of theater, for example, or by film and so. So, well, I just like to repeat that creativity is important in restorative justice in general, but certainly also in environmental restorative justice.
Does a dividing line happen between creative, restorative responses and civil disobedience? Is restorative justice, does it embrace civil disobedience?
Well, I think there should be a place for civil disobedience in these cases. That is not a fundamental problem, I think. Well, I think, as usually in restorative justice, we should not stick too much to legal definitions and legal interpretations. Restorative justice processes should offer a space where also these legal approaches and legal definitions can be questioned, can be challenged in a positive way. And civil disobedience might fall under that, I think.
Can you give an example?
Shall I?
I personally do not have examples of that.
Has one. Laurens?
Yeah, I was gonna suggest this, Ivo. You may have better ones than this, but one I'm currently involved in is in East Africa, where communities have been deprived of their lands by the British colonial regime about 120 years ago. And the result has been an ongoing dispute between those communities and those corporates to whom those lands have been sold, as a matter of fact, for tea plantations. There has been a history of civil disobedience. There has been a history of civil unrest. And one of the factors in getting the engagement, which I hope to heaven we get from the purchase of the land, is that they will reduce the civil disobedience, if we call it that, that is part of the protest of those communities who to this day continue to object to what's been done to them and their families and their forefathers, forebears. So it's not directly relevant, but it is part of the background that may hopefully bring the corporate to the table.
Thank you, Lawrence. That's very helpful. I'm going to bring in Marianne Liebman now because she wants to ask a question about the establishment of ecocide law.
Yeah, I think there's I've also put it in the chat. There's a movement to establish an ecocide law, and there are also people talking about how to incorporate restorative justice in that. And I just wondered if Ivo and Lawrence and maybe anybody else has any kind of ideas about how that should be done.
If I may, Myra, in this working group of the European Forum, we have indeed done some work on this topic of ecocide law, and we had cooperation with the European Law Institute. It's a European organization that is supporting governments and other entities and people drafting European law and so on. And they are in the process of drafting a European Union directive on ecocide. Ecocide is already criminalized in some of our countries, but in most of our countries not yet. Mm-hmm. So there are attempts made at this moment at European Union level to adopt binding legislation in the form of a directive, for example. So it would mean that all the member states of the European Union have to implement these legal provisions in their national legal order. And there we have done some exercises indeed on how could that be included, restorative justice in cases of ecocide or responses to ecocide. We have come up with a definition on restorative justice in cases of ecocide, but I will not read this definition now. We have also commented on the penalties that were proposed by some experts in Europe. And in a general way, when the European Union is revising its legislation on environmental crime, there's an important directive of 2008 in the European Union, and it is being revised. But the main objective or an important objectives of the initiators of this revision in the European Union was to make policies and to make sanctions, criminal sanctions, more what they call persuasive. More deterrents. And we had a whole discussion with several people on how or whether classic sanctions are so deterrent and what the effect might be of participatory processes such as restorative justice. So yeah, there is some work being done, and yeah. I could send you, Marianne, this document that we prepared at the moment.
Yes, please. There is a group that I'm in touch with that's very interested.
Mm-hmm. Shall I then add, sorry, Myra, shall I just add one thought? Because the question came up of how to integrate RJ into the law of ecocide when the late Polly Higgins ran a mock ecocide trial in the Supreme Court in London in 2011. And the way that played out, and she made sure that RJ was part of the proposed ecocide legislation that she drafted, was that the trial took place, the defendants were convicted, they were asked if they'd participate, two of them asked if they would participate in an RJ process. One said no, one said yes. The one who said yes was party to the process. It took 5.5 hours. It was pretty intense. At the end of it, we came up with a series of actions that were agreed upon by all the parties, which were then put forward to the court. And when the judge sentenced, he sentenced the first defendant. These were both played by actors, these defendants, I should say. But the first defendant was sentenced to a term of imprisonment for the ecocide crime that he'd committed. The second defendant was given a deferred sentence. In other words, no sentence was passed for 6 months, provided he implemented the agreed upon actions that came out of the RJ process, which, since it was a fiction, of course, we don't know whether that would have happened or not. But the likelihood is that when he came back to court, he would have received a much more lenient sentence as a result of engaging with the agreed on actions.
Super, thank you. Now we're coming very close to the close. We've got maximum 4 or 5 minutes left. And I have 2 questions on the chat box, which I want to give space to. Firstly, to Rosie Chadwick, and then to Douglas McFarlane. Rosie, who's here in Oxford, the chair of the Mint House, and then all the way to Sydney, Australia, for Douglas McFarlane. So, Rosie, please.
Thanks, Mara. I just wanted to ask what's needed to make, and you I think started to answer that question, what's needed to make environmental restorative justice the norm and not the exception?
Who wants to answer, Ivo or Lawrence?
Well, that is a difficult question, of course. And we all wish to make it the norm much more than the exception, I think. That's related to all kinds of harm and crime, I would say personally. But of course, that is a long-term strategy that is needed, I think. And as with restorative justice in general, we must work much more also at the political level, I think. So to consider and to make it happen that restorative justice is a right. To participate in restorative justice should be a right for people, for all the stakeholders, whether it is on the victim side or on the perpetrator's side, or from the community. But of course, that is easily said, but not so easily realized. But okay, we are working on that, and organizations as the European Forum, I think, are doing a lot of work into that direction as well, to enlarge access to restorative justice and to consider it as a right for people.
And I'd add to that, if I may, that the part of the way to make it happen is what we're doing at this moment, which is publicizing, disseminating these ideas, discussing them, and having people understand better what it is we're talking about, and then hopefully talking to their friends, talking to their colleagues, and the ideas get spread out. It's a political question as well, as Ivo has said. It's also about the media and public opinion. And in the end, it's about us as individuals, because there's nothing in this country anyway that says that you can't have a restorative justice process in any of the contexts that we're talking about. So actually, if there are lawyers listening, if you've got a case that has an environmental element, before you try to get the courts to rule on it, try an environmental process. If you're an individual who knows about an environmental issue, who's a party to it, before you sue, or when you sue, also have in mind the possibility of dialogue, so that each of us as individuals has the possibility to change the culture that that Ivo's talked.
Thank you both very much. That's a really helpful practical response to Rosie's question. So the last question comes from Australia, from Douglas McFarlane, and it takes us onto the edges of legal structures and back into the wider ecological justice and environmental restorative justice dimensions. So if you're with us still, Douglas, do you want to speak?
If I can. So my question is, what work is being done in the more broader concept of restorative practices? I suppose Lawrence's example kind of goes there a bit, in that it didn't necessarily originate from a court saying, go and do a restorative justice process and come back to me and tell me what happened. It's more of, how do we, what work is being done in terms of issues which aren't centered on just the justice system, just the criminal system, but also just broader environmental human conflicts that can be resolved through restorative practices, circles, getting groups together to talk together as human beings to resolve their conflicts, so that, there's less harm to the environment, not necessarily in that criminal framework?
Yes, if I may say something about that. I understand your question, but I think also all human conflicts have an element of justice, I think. And justice should not be identified with criminal justice or even not with institutionalized systems of justice. Justice is also an experience and a practice that should be done by all of us, also in our society, in the community and society. So it all depends on your understanding of justice. But I think, personally, for me, the distinction and this debate between is there a difference between restorative justice and restorative practice is not that crucial for me. Because also in formal processes, when people talk to each other, and also in the example that Lawrence has given, there is a lot of justice at stake, even when the justice system is not intervening. Justice is something that should be exercised and be practiced by the stakeholders themselves. And that's why restorative justice or restorative practices, as you wish, are so unique and offer an important opportunity, I think, to make justice happen in our societies. And of course, it always relates to the way how the justice system is contributing to justice. But I think we must see these dynamics and this interplay between informal justice mechanisms and formal justice mechanisms.
Thank you very much indeed. Friends, we have reached the end of our time and the chat box is getting more and more full, which says to me that there is a lot yet to be discussed and we can consider what areas from your chat box questions might possibly be the subject of a further session. But for today, I want to give sincere thanks to our two presenters, to Ivo and to Lawrence, for very stimulating discussion, and to all the questioners for pouring hard into this enormously important subject. Joy, can I hand back to you, please, to close up our session?
Yes, thank you so much for coming along. Just a couple of things to remind you of. I've just put in the chat the link to the evaluation form, so it'd be really, really great. It's a really, really short form. If we could have your comments on today to help us improve future events. And if you have ideas for future events, please pop them in there because we're always looking to suggestions. If you click the link on there, then the link will be open in your computer or your device, even when this call finishes. And also please have a look at our upcoming events. We have an event in December about restorative schools, which is really exciting. We have a number of speakers lined up for that. And also in the new year, we will have an event on trauma-informed restorative practice. And we have a few other things in the pipeline that aren't sort of confirmed yet. So please sign up to our mailing list, keep looking at the website, on our social media as well, so that you will hear about everything that we're doing. And yes, thank you so much again to our speakers today and for all of you for coming. And we are so grateful to be able to gather like this. And yeah, have a great day.
Cheers, everybody. Goodbye.
Bye-bye.